Okay. So good morning, one and all. This is a webinar on cracking judiciary with Mr. Ashutosh Shukla. So I'll give a brief introduction of Mr. Ashutosh Shukla. First of all, a very happy International Yoga Day to all of you, and I hope you're doing well at your homes during the pandemic, and I hope yoga actually boosts your immunity, as the Prime Minister does say. So Mr. Ashutosh Shukla is a native of Varanasi, and he actually finished his schooling from Lucknow. Then he joined National Law University Visakhapatnam in 2013, and then he graduated in 2018. In 2018 itself, he cracked the UP judiciary, and there he is with us working as a civil judge and the guest for this webinar today. He has been exceptionally good with his subjects and also in sports. So now we'll get to know as to how did he manage with his sports and academics and the regular curriculum. How did he manage to become a civil judge at first attempt? And he had also qualified for the prelims in Uttarakhand and Rajasthan. And when his UP prelims got cleared, he didn't opt to go to Uttarakhand or Rajasthan. And in the interview also, he scored a whopping 77 out of 100. So there we are with him, Mr. Ashutosh Shukla. We are very happy to have you here. You are an esteemed senior for us, to all the DSNLUites, and you are a great inspiration. So so there we start. That's the brief introduction of Mr. Shukla. I hope that all of you actually benefit from this session. So the first thing which I'd like to ask you, Mr. Shukla, is that how did you prepare for judicial services, and did you actually have it in mind ever since you joined the law school, or did you have it later? Like, did something happen, like, okay, some turning point, and I don't want to go to corporate like all other friends are actually into, and I want to go for judiciary? What was the motivation behind going to judiciary?
Yeah, thank you for the introduction, Sunanda. Hello, everyone. I hope you all are fine at your home and doing well in this pandemic. The basic thing that you have asked, that how could I have managed everything so well, was that I was focused at a time whatever I was doing. Like the moment that the classes were going on, we were focused upon the areas of learning. The moment we were playing, we were on the ground, we were dedicating 100% to the same thing. Now, coming to the idea of being a judge or getting into judicial services was never I did not think of so. In the last year of my college, when I was in the fifth year, my parents basically pursued me to go for this venture. Thereafter, I made up my mind after the graduation in 2018. Afterwards, April. Thereafter, I started with the preparation of the judicial services. Basically, I wanted to go into the litigation. All my internships during the law school days and everything that I focused was becoming a lawyer. So, but I did not opt for the same. So I went for a coaching in Delhi, and I joined Rahul Saiges, which is there in Delhi, and there. But my coaching couldn't get completed because in between only I got selected for this UP Judicial Service.
Oh, nice. Yeah. Okay. So now there's a very basic question that anybody who comes to law school, and generally people from national law universities have this notion of going into law firms. So how did you not have that sort of a bent of mind that, why should I not join a law firm and just start making money like all other friends are actually making money, and then there are a lot of placements which start from your third year, fourth year itself. So did you feel demotivated about it anytime, or you just always had your own plans?
The basic thing which I want to convey to people through this medium is that the very first thing what a person should do is a introspection. That where a person wants to go. I would suggest everyone, starting from the people who are there in the first year or the second year, and to all the law students, that you should explore all the venues of the law field. That you should do internships in the corporate firm as well. You should be going for the litigation internships as well, because internships are playing a very vital part in shaping your career options. The very first thing I did not make up a mind for a particular thing when I joined law school. I did not opt, or I did not have the notion that I'll be going to a law firm, or I'll be going for a litigation, or I'll be becoming a judge. The very first thing that I did was self introspection. That you should self-analyze yourself, that in what particular field you are best in, give your 100%, and and it goes by the actions as well. Like I would like to suggest all of the people who have joined this video that you should be exploring all the avenues. You should be doing internships in all the sectors as well. Then you should make your mind. I do not consider a law firm or a corporate job to be a bad thing, but it was not my cup of tea. Basically, that's why I did my two of my internships in corporate law firms. But I thought that it is not my cup of tea. I do not want to join this sector. Maybe I'm good into litigation, so then thereafter I shaped all my internships into this litigation based one. I've interned with the senior advocates or the high court judges, but thereafter I changed my mind. But after fifth year, when the people were getting placed, I did not felt demotivated, or I did not feel that why am I not being placed, because it is their point of view. People are thinking about their career, and there are diversified people in my batch. If you see my batch only, there are people who are into academics, they are doing so well. There are people who are
Yeah.
into litigation, they are doing so well. And then there are we people. We are there, three or four people who are into judicial services right now from my batch. So it
Yes.
depends upon the notion of a person. So the very first thing that I want to say and convey to the people is to self-analyze your potential, your strength, and what is your passion basically. Do you want to be a litigation lawyer? Well enough. Do you want to go into a corporate firm? Well enough. That depends upon the person. So you should keep your mind open, and you should explore all the avenues that are way possible into this sector. It is not necessary that I have cracked UP Judicial Services or I have become a judge, so everybody should follow this stream. This is one of the options from the law stream, but it is not the only one. There are other avenues as well, and people should explore, and then they should decide that which field they want to go for. So this is my basic advice for all the people who are there.
Right. So a lot of people are actually aspiring for becoming judicial officers. So I would like to ask you as to what are the pros and cons of becoming a judicial officer, not professionally, but when you compare yourself with your other colleagues or other batchmates, etc.
Yeah.
So how do you see a judicial officer, you know, uh, like a judicial service as a profession, or how do you perceive it? Like, you are a judicial officer, you know the nuances of the system and how does it run. So do you think like we can actually give out or give back to the society by becoming a judicial officer?
Exactly, we can give a lot back to the society by becoming or by coming into this judicial service. I consider this profession as one of the most noble profession, because you are deciding at the benchmark of the courts. You are straight away going into the subordinate courts. You are handling the main problems. The main trial of the cases are being done at the subordinate courts as well. So we as judicial officers who are being recruited at the lowest level go to the depth, go to the analysis, go to the evidences, go to the facts, and then we evaluate upon weighing. It's like weighing which scale is more higher, or where the evidences favor the person or the party. Now, coming to this, that what are the pros and cons of being a judicial officer? I don't think that in any service there is some pros and cons, but right away when you are a judge and when the society looks upon you, then obviously this is a very dignified profession and dignified job. You have to maintain your dignity as a judicial officer wherever you go, wherever you speak. The second thing is that there is this basic humility that you should always carry. Being a judicial officer, you should be always be humble towards people, upon listening upon their problems, upon the advocates who are representing the cases of the people. Then the third thing which comes into the mind that being a judge is that there has to be a aloofness from the society. You cannot mingle with the society at very large scale. Like if you see the job of the executive goes into the public domain every day, solve their problems, day-to-day dispute. But we, being the judges or being the part of the judiciary, we cannot go to public at large or go and decide their cases there and there at the spot. So there is this procedure, there is this separation of powers where the judiciary itself is an institution to decide the cases in the court as well. We cannot go outside and interact with people freely. We have to socially boycott the society, not at the large, but to some extent that we should not be mingling too much with the society. We are always open to take the ideas or take the opinions of the people as well. You should be always opening your mind. You should not have a narrow mind that you are not taking anyone's argument into your
Consideration.
into your
Yeah.
consideration, or you are not letting others speak. I said that being humble and humility is one of the greatest thing what a judicial officer always has. Coming to the advantages, there are 100 perks that I can define, but it is not feasible. It is not feasible at the right moment that I should be telling about the perks of being a judicial officer. But yes, it's a dignified job and it is a noble profession. If any person wants to come into, this is one of the best jobs that I think. Earlier, my notion was also that being into the litigation or opting for the litigation would be a feasible idea for me. But once I've stepped into into the shoes of a judge, I consider this job as being the very best, and I'm fully satisfied. There are no disadvantages as well because there is no person to like guide, no one to supervise you to how to deal with the things. If there is a particular criminal or civil case, whatever cases you are trying in your court, whatever order or whatever judgment you pass, you are accountable for it. Nobody can put a pressure upon you to decide in this favor or to approach in a similar way. You are independent in your own case. Though you have certain guidelines in which you should act upon and you should never cross. Every profession has a limitation and foundation, and we are also bound by the service rules. But what I want to say is that the judgments and the order that you pass, there is no kind of self imposition of other people, your seniors or anyone. If you pass
Right.
a particular judgment or the order, you are accountable for it, and you should be that. There comes the idea of the legal acumen that a person has. So I don't think that there is any advantage into this disadvantage into this profession from my point of view.
Okay, right. So, like, since you are a senior from my university itself, so I have known you. You have participated in a lot of moots, debates. You have won mock trials. You have won the debate conducted by British High Commission, right?
Right, yeah.
So, having been involved into all of this, like, did you feel that any of this had a advantage to you when you were actually preparing for judicial services?
Right. So when you are into college and when you are doing debates or you are participating in moots and mock trials, it very much inculcates the idea of being vocal to the people, representing your ideas
Right.
to the people, what you think of a particular issue or of a particular situation that is being given to you, and the idea of convincing that the style of debating is always what I think is that it should always be convincing and pleasing to others. That how can you please whatever topic you get a very bad topic, some of the times you get a very bad topic and you say that you cannot defend it as well, but you should be having those vocal capabilities and abilities to please the other party as well and to the audience at large as well. The very first point that I got very much advantage by participating into these moods and debates was getting knowing the depth of the law. Like when you are researching for a particular problem, particular case, or particular situation, you are going to a plethora of cases. So it
Yeah.
helped me a lot. I studied a lot of cases into the depth. I studied the facts, the ratio disindicate, the main ratio of the case. So it helped me a lot. It helped me to think as a person, to widen my scope of thinking, and to frame the arguments into my favor. The very first thing that it built was a case law study that is very much needed in judicial services examination because once I'll be discussing the strategy for three means when you will be writing the mains, there comes this part of yours that you have studied the case law or not. Because because there are hundred of sections and articles in the constitution as well as the other acts where the provision is not very much clear about where the provision is not very much clear what it wants to say, but the interpretation that is given by the Honorable High Court or the Honorable Supreme Court has really paved the way of interpreting that provision. For example, if you see Article 21 is nothing. It's just straight away one line. But if you see
Yeah.
the impact of Article 21, it has been everlasting and it is like ever growing. If you see the recent example of cases is like right to privacy, right to choose a partner, the LGBT rights, all these case law have particularly emphasis upon the Article 21. The personal liberty and the personal freedom of a person plays a lot of role, and thus the state has to give those rights and they have to recognize those rights to a people, and that is what has been done. As I was saying, that Article 21 is just a bare language. It is just one line article, if we see. But the interpretation that is done by the Honorable Supreme Court and the High Court is tremendous and amazing. So, by debates and by moot courts or mock trials, you get to know the depth of law, you get to know what are the relevant case laws pertaining to that particular section of the problem. You get to get vocal about the speaking of the oration skills, because being vocal is one of also the advantages into the interview section. When we go for the interview of the judicial services examination, for suppose if you take my interview only, uh, I think that I have participated in moods debates that helped me a lot, and all of the panel judges who were there, they appreciated this fact. And when they went into the depth of asking the case laws or the particular sections, I was very much vocal. I was in a better position to tell them about the same, about explain them. And the third thing was that I could very well convince them. So I think that participating in moods, debates, though you win or always helps persons. What I want to convey is, yeah.
Okay, right. Uh, so, so this is a suggestion from your side to all others, because there are a lot of people who are actually preparing for judiciary. I know them personally, and they aren't into moots and debates. They feel that preparation for judiciary is, uh, the biggest thing they'll have to do during the law course. So your experience is a good addendum to them to convince them that it's not only preparations but also your extracurriculars which do matter. How did you manage your academics while you had a thought about judiciary as well?
Academics, I was always very well into my subjects and into the academics.
Yeah.
The subject which interested me, I studied them at large, like the Constitution of India, the CRPC, the IPC, Indian Evidence Act. I always particularly focused into these sections because I've always, as I discussed earlier, that the moods or the mock drills that we went for were always into this kind of particular problems. We always selected the
Yeah.
criminal side of moods. We never went for the international law.
Right.
I was not interested in international law or the company law or the corporate law, but I was always interested towards the constitution and as well as the criminal law. So, being into academics, only one thing I want to say is that whatever you learn in college or whatever you see from the college remains there as well. But once you are a judicial services aspirant, there is a major gap between the two, because the legal education and the curriculum of the legal education is not designed on the basis of a judicial services aspirant. Many of the
Yes.
points are often overlooked by us also and by the faculty also, because the faculty over there in the law colleges are not teaching you to become a judge, or they are not teaching you for the examination purpose. So what I want to say is that you should always refer some of the books that are the basic books. You should always refer them along with your subjects. What I did was the subjects which interested me a lot. I always had a book for the same. Like for the Constitution of India, I had this J.N. Pandey with me. So I went. I though if the particular things or the articles had not taught by the particular faculty in the college, I always looked into the same. I went into the case laws. I made my notes. I made a separate register for all of them. So I started making notes for them for the important articles or for the important sections. Similarly, I went for the CRPC. I did not go from right away from starting from section 1 to the end of the CRPC or section 1 from IPC to section 511 of the IPC. I went into the phased manner. I went into the phase manner. For suppose if I give you an example, for if I talk about CRPC, you will always be thinking about what is the right procedure to study CRPC. What I had the procedure was that if you take an example that suppose there is a commission of an offense, first there has to be an into the CRPC, then the particular information about the same has to be given to the police to the police officer. That stage is called the lodging of FIR. There comes the criminal investigation. Then there is this police report filed. Either the charge sheet or the final report is filed by the police to the court. Now this whole part, the commission of offense, lodging of law of FIR, criminal investigation, is dealt from section 154 to section 174 of the CRPC 1973.
Yeah.
So I went into this procedure, that I went into the phase wise. I always went into a progressed way into the phase wise. When the police files a charge sheet or the final report, then comes the role of the court. The courts take the cognizance of the same, then either the court has to grant bail or not. Then there are certain phases which is presented before the court. There comes the role of the court. So I've always bifurcated the subjects, I've always bifurcated the parts, and I've gradually shifted towards my studies. I went into the basic things of what I want to convey to all of the judicial services aspirants as well as the law students as well, that you should be clear with the fundamentals very firstly. Very first thing is that you should be clear with the fundamentals of the subject. What are the basic fundamental of the subject? That suppose that what is the difference between an inquiry and an investigation? That is itself is given into the definition clause of the CRPC, and that has to be understood by the judicial services aspirants. So that is the way I'm telling that this has never been taught into the college, that you have to go into this gradual way. This is what I have learned after my college days. Though you have some of the knowledge that you gain from the college in your mind, the case law study, or the relevant or the landmark section you may be knowing, but when it comes into the wholesome knowing of the subject, there we people lack a lot. So this is my suggestion, that you should be bifurcating the subjects, bifurcating into the parts, understand the fundamentals of the subject, and you should approach for the same.
Okay, right. So now I'll ask you something very personal as to what was your routine when you were preparing for a judiciary?
My particular, see, I have never believed that there should be a strict schedule for cracking. This is my personal opinion, of course, because if you see, there may be people who may be telling you that you should be waking up early in the morning and then you'll be starting with the revising your subjects. Yeah, it is there, and people do adopt this strategy, and they are being selected, of course. But my strategy was a bit different. My strategy was that I was always a person who studied in the night. So my strategy, if I
Okay.
tell you about my schedule, uh, I would start my day. I'll be waking up by 9:30, 9 or 9:30. Thereafter, I started with the subjects, with the revision parts, the subjects part. So I studied for the
Okay.
first 2 hours. I always studied for the GA, general knowledge. For the first 2 hours, I studied newspapers and magazines. The next 2 hours were dedicated to GS part, that was history and geography, studying history and geography. Then after in the afternoon, I took a short nap for like 1 hour. Then after that, I started with the law subjects. the whole evening shift and the night shift went into the law subjects. So from 3 to 7, I studied my law subjects. Thereafter, I had a break. Then I went for some like a refreshment for a walk or listening to songs and whatever a person likes in his leisure time. So after 9 to 3:30 till night or 4 in the night, or you can say till the
Oh my
morning,
God.
I studied the law subject. So this was my schedule I carried upon. The
Okay.
very first thing I want to like when it comes upon building a strategy or building a schedule is that you should be existing upon your saying. You should not be sacrificing things. I never sacrificed my schedule for else's schedule. Like there were people with me. There were people with me who were living with me. They had this strict schedule of waking up at 5 in the morning. Then they were going for their studies. That is very well. But this is what my kind of schedule that I have adopted in my college days. So I carried the same till my judicial services preparation. So very first thing is that you should not feel that that preparing for a judiciary or preparing for a competitive exam is a burden upon you. It is not at all a burden. Take it in a serious way, but enjoy what you do. I always enjoyed whatever I did. I always enjoyed whenever I studied. I always thought about it. Whenever in my leisure time also, or when I was going for a walk, I always imagined the things or the particular situation, whatever I studied about. Because going through those things and thinking upon yourself takes a lot of effort, and then only the things remain in your mind. Because
Yeah.
when you write for the mains examination, there will be like 40 subjects that you have studied, 40 different subjects, and keeping all of them in mind and keeping all the sections and all the articles and remembering all the case laws is impossible. So this is the funda or the strategy that I had adopted for me. So my suggestion for the people is that they should be like they should be giving at least 8 to 10 hours of a serious study if they want to go for the judicial services or any type of competitive exam preparation. The first should be going for the current affairs. Current affairs plays a major role, be it the preliminary part of the examinations, the mains part of the examination, or even in the interview. How well aware are you of certain things of your nation or things that are going on the world plays a very important role. Then the second thing which should be emphasized is the GS part. GS part consists about the history thing, geography, economics, and science and tech. So you should be always spare your time in such a way that you give at least 2 hours or 2.5 hours to GS part as well. Thereafter comes the role of law. Then for law, you should be giving at least 6 hours of study. I do not say that you should be studying a particular kind of subject, the same subject for long stretch of 6 hours, but you should be picking up two subjects. See what my strategy was for the judicial services preparation. I always picked a very easy subject that you can say and a very tough subject. So when I started with my preparation, I picked up TOTS, law of TOTS, which is basically taught in the first year in our law school. So I
Yeah.
picked up TOTS, then I picked up CPC. So there was no kind of stretch and there was no kind of mental. You are not mentally exhausted from studying the same subject, or you do not get bored. The same
Yeah.
my strategy that I took TOTS, then I took CPC. Thereafter, after completing TOTS and CPC was little bit left, I went to contracts, law of contracts. Law of contracts is also a bit easy subject and easy to understand. Thereafter, when I completed CPC, I started with CRPC. So at one part, then when you have an easy subject at your hand, then the routine or the phased manner of your preparation goes very well, because then you get interested
Okay.
into the subject. And I've been like I've been also mentoring my friends who are preparing for the judicial services preparation in the same way, that you should always pick up an easy subject which is very well to go, and then there should be a complex subject or the toughest subject that you are scared of. Basically, CPC scares everyone. It scared me doing well. So I
Yeah.
this was my strategy for the judicial services preparation. Yeah.
Yes. So there are a lot of questions, and there was one question as to how did you decide as to what case laws are important?
What case laws are important? See, when you will study a particular section, there will be a majority of conflict of opinions. As I already said, please refer a book. Do not study only from the Bare Act, because if you study from the Bare Act, that is only for the purpose of the preliminary examinations. You can get through the prelims examination, but when it comes to the applying your legal acumen and answer writing skills, there comes the need of the reference book. If a person is not opting for for the coaching classes, if a person is doing a self study, then he should at least have a single book for the reference of the same. For like, if I talk about IPC, the best book which I consider is for the reference is KD Gore, because if you study KD Gore, there are the way of the way of writing the book, or the way the author has mentioned the particular provision, is excellent, and that is very much needed in the examinations. Like when we talk about section 300, which defines or explains murder, the same thing has been described in KD Gore in a very phase wise. Like, what are the ingredients of the same? Whenever we go for the criminal law or for the any criminal act, if we see IPC, there are two important things which play a major role, as we always know. An offense always comprise of mens res and actus reus. So
Actors, yes.
yeah, exactly. So this thing has been very well described in KD Gore, and when you will study KD Gore or any kind of reference book, whatever a person is referring, there you come to know that there are particular sections in which the law and the provision is not very much clear. If we see KD Gore, if we see KD Gore, and there is this mention of section 300, then there is this case of rarest of rare cases. Because section 300, which defines murder, is punishable under section 302, and it talks about that the offense of murder is also punishable with death. But if we see the concept of Indian judiciary, we are totally inclined towards the capital punishment. So there we derived an idea of the rarest of rare cases. So from where this concept came, it was the interpretation of the Honorable Supreme Court in the case of Bachchan Singh versus State of Punjab. If we see there, the concept of rarest of rare cases came, that what category of cases fall under the capital punishment and what category of cases we can punish them with 10 years of imprisonment, or it depends upon the gravity of an offense. So you will get an idea once you start reading the book along with the Bare Act. You will get the idea that which are the more important case laws to have to shift your focus. For example, if I talk about Article 21 in the present purview, then I don't think that there is clear authority, case Kutuswamy versus Union of India, the right to privacy case, because it has been adjudicated benign in this stage of the Honorable Supreme Court. Case Kutuswamy, and because of case Kutuswamy, right to privacy case, many of the rights have been recognized by the Honorable Supreme Court on the basis of this case only. If we talk about Navteej Singh Johar versus Union of India, which talks about the LGBT rights to the people, and like declaration of Section 377 as unconstitutional laws, the Nas Foundation case,
Yeah.
the Suresh Kumar Kaushal case,
Caution.
then there comes near Navteej Singh Johar case. So you will get an idea once you start reading, you get into the habit of reading the books and the reference book. You will have an idea that which particular case laws you should go for. I do not say that for every particular section there should be a case law with you. I do not emphasize on the same, and it is not practically possible. But for the landmark sections, you should be having an at least landmark case law upon the same upon and a landmark case authority to write into your judicial services examination. And the first thing, and also now when we are into this digital age, I suggest everyone to download Live and Bar and Bench. It is very much easy. It is very much easy and feasible to like scroll through. You should be maintaining an register, like what I used to do when I thought of getting into judicial services preparation. I had this separate register and separate notebook wherein every day after, whenever I went to sleep or whenever I was free, I was just scrolling or browsing my phone, I went through Bar and Bench or Live Law. I went and I saw what are the landmark cases which is being decided today. It takes hardly 15 to 20 minutes to scroll through the whole segment of the legal news, and then you will get to know that yes, like these are the guidelines that has been implemented today by the Honorable Supreme Court, or this is the landmark case law that has been decided by the Honorable Supreme Court. So make a note of that will eventually help you in the plea as well. Names and the cases are often asked, and the cases and the ratio decidendi is often asked in the interview of the judicial services examination. To me, they have asked a lot. Even you cannot imagine the panelists, the judges who were in my panel, they have asked about the name of the judges who were there in decide a particular case. So, like case would Swami, there were 9 judges who were there to decide this particular case. So I was even asked, can you tell me the names of the judges? Because they do not want a particular person who is just like saying that he wants to be a judge, but his actions do not know. I think that you should take the observation of the judges, what they have held. So I remembered about like 5 to 6 names of the judges. So this gives an impression to the panelists and to the judges who are there in your interview that yes, this person has actually studied, he has actually worked hard, and he's not for the mere purpose, well, and he's not going into an area of fakeness that yes, I've read this thing, but once they ask about the same, then you do not remember. So for me, the very first question was asked in the interview was this question. The next question that they asked was that, can you tell me about the people who were there in this Shaira Banu, the where the Shaira Banu case dealt with the triple talaq being unconstitutional. So they even asked me that, can you tell me now, can you tell me the who were the judges in this particular case? So I remembered everyone, like it was a 3-2 judgment. So I even remembered the people who dissented the judgment and the people who were in the majority who gave the majority opinion. So I think you have to be a bit more focused and serious when you are deciding to opt this field, and this is all your interest that it takes. I had always interest. I had always interest reading the judgments, reading the opinions of the judges, what they have said, even the dissenting opinion, what they have said and what they have held, and this very much helped me into the interview for cracking the interview and getting the even the highest mark in the interview as well.
Okay. So how important, according to you, are the previous year question papers?
Oh, yes. Oh, the very first thing when you decide to be a judicial services or any kind of services you are applying for is the very basic mantra of knowing the nuances of the questions is going through the previous year questions. So I would suggest everyone that there is this singles publication book there in the market. It is a bit bulky book, but it consists of all the previous year question papers of preliminary examination of all the states. So you should be deciding upon the states that you are focusing. That if a person is focusing for UP, Delhi, or Uttarakhand, so there is this book where there is a question paper of all the states where you can go through and you can easily flip upon the pages, and you can see what are the areas to be focused upon. The basic mantra of getting into this examination or preparing for the examination is that studying of the previous year question papers, that knowing the areas which are often asked. So you can go for this book. This singles publication book is there in the market. You can take it and you can just go for the states which you are focusing upon. But I would suggest that you should be solving, like you should be seeing upon the all the states, the question paper of all the states, because there are somewhat differences in the into the syllabus of all the states. The syllabus of all the states are not same. If we see Rajasthan, there is if we see the syllabus of Rajasthan Judicial Services, there is no mention of GS and GK is not being asked over there. They only ask about law, but there also plays a major part of Hindi. If we see UP, if we see UP Judicial Services of Bihar or Delhi, there comes the role of GS and GK. The role of GS and GK is very much important there, and you just cannot ignore, because there is the separate paper for the GK in the preliminary exam as well, and and then there is the same paper of GK and GS of 200 marks in UP Judicial Services in the mains. So you cannot overlook all of them. So the better idea is that you should be having a basic idea of going through the previous year question papers, and knowing the areas which are often being selected and being asked in the examinations. So the very first thing is that you should be having previous year papers of the particular state that you are focusing upon. Then the second thing is that what I want to convey to people is the reading habit of newspaper. You should all every day you should be reading newspapers, either the Indian Express or the Hindu. You should be like reading it thoroughly, the editorial part or the polity and governance part, and the national news as well. So and also you can refer the economic section and a bit of sports section, because it is very much feasible. You get to know the ideas and opinion from the editorials, and because there are certain papers. If we see the UP Judicial Services examination, there is this language paper where you have to write an essay of 60 marks. Of 60 marks, you have to write an essay into the same. So, uh, gathering the points of essay, gathering the opinions and ideas and fact and can be very easily collected by the source of newspaper. Okay, so it is my humble opinion for everyone to go through the newspaper. Do not overlook the same, because do not think that you are like competing with a single person. There are people now who are very much smart, and they leave no stone unturned for getting selection into judicial services. And now the concept of asking questions getting in is not like the theory part of things that are being asked. Now they are giving the problems, the application-based problems are asked. So you have to develop that legal acumen, and you have to be like very much equipped with all the recent awareness that is being happening into your surroundings or in your nation, or there is a major happening that is there worldwide. You should be knowing about the same. You should be maintaining a register for the same. Like I always maintained a register. I had monthly register for the same, for the GK part. I always had this one monthly magazine for current affairs. For suppose I took competition focused by the Aryan publications, and I also studied newspaper, the Indian Express. I do. According to your convenience, you can also take any of the competitive exam magazine. For there are many magazines in the market. You can flip through the pages, whatever you like you can take. There is no compulsion that you should buy this kind of magazine only. There are like Pratyogita Darpan in the market, that competition success review is there, competition in focus is there. So there are different variety of magazines. Choose, but do subscribe a monthly magazine, and do study and have and make notes for them, because it really helps you a lot when you are writing the mains examination. Because when you want to have all the material before you, it will be there in a particular register. You can easily flip through pages, you can easily highlight the particular things, and it is very much convenient. The main problem is faced when you are writing the mains examination, because there are hundred of opinions or ideas that what you may have read, but you cannot like conceive it, or you cannot recall it, remember it. So the better thing is always to write and learn, to write, learn, and revise. So I always followed this thing, following the newspapers, reading the magazine, making a short notes for them in the register. Daily, I used to write like 10 to 15 news articles, or what are the major news headings that are being there in today's paper. So I always went through that. I always marked them with the highlighters or with the pencils. So this is an idea, because this is what strategy I have adopted. There may be people who are more innovative, like many of my friends, if I talk you about, who are now judges. They had this compilation of case laws into their laptop. Like many people, they read from the live law or the bar bench, and they had this particular word format into the laptop, and they used to write all the case laws, and in a very short paragraph, 7 to 8 lines, what was the main ratio and what was held in that. So these are the particular way of strategy. When you are thinking of cracking an examination, then it is in global competition. The examination is being attended by lakhs of aspirant, and they have different kind of strategy, different kind of their plan of action, what they follow. So what I always thought when I was writing for the mains or when I was appearing for the interview was that you should always have this notion in your mind that you have to be smart from people. Like when I was writing my mains, there were like 6,000 people who were writing mains for the UP Judicial Services examination. So whenever I was
Okay.
writing or attempting a question, I always thought that what should be the style of writing? How should I write? How should I present my answer, that the examiner or the person who is evaluating my answer sheet should appreciate that yes, this person has an edge over others. I always thought this, because this is a competition and you have to be self-centered, self-focused. You cannot like just write in a haphazard way, like just filling the pages of the answer sheet that we used to do in the law examination. That is not at all being done. You should be short, you should be crisp, you should be clarity. There should be clarity in your answer writing skills. So I would suggest people that read and write. These are the basic two things that you have to follow anyways, because if you do not write now, once you may have like cracked the preliminary examination, but when it comes into the area of means, then many of the people lack, and means is the backbone of getting selected into any kind of examinations. If you see, be it UPSC, be it judicial services, be it any kind of thing, the mains is the backbone of all the examinations. So you have to be very much perfect about your answer writing skills.
Okay. So from when did you actually start subscribing to the magazines for your general current affairs?
Yeah. So whenever, like, if you are appearing for suppose that there is an exam, there is a particular exam of the state that is to be scheduled in 2021. So what I used to see was from April 2020 to March 2021. I read to study. I basically used to study all the magazines and the current affairs news, because they generally focus upon between that year, the exam in which it is scheduled, they ask for like for the last 1 year current affairs. And most importantly, you should be very well focused. Like if your exam is scheduled in March, suppose there is your exam is scheduled in March, you should be very much well aware of last 4 months current affairs. They really ask a lot about December, January, February, and March, because you should be
Okay.
very much thorough about them, and you should be knowing each and every bit of details, what you should be knowing for the purpose of your examinations. No, going for the revision of 1 year current affairs is must. But there also, if we go for a subset, then you should be focusing of the last four current affairs, of 4 months current affairs news, whenever your exam is scheduled. So
Okay.
it is like go for the one year current affairs. And also you can get a yearly current affairs magazine that is there. There is this annual subscription of many of the current affairs magazine, but the details are not very much there. They only pick and choose things. They do not like, if you read a monthly magazine and if you read an annual subscription and an annual magazine, there will be a hell lot of difference. So you should be going for the monthly magazine, and for revision you can have an annual magazine for the current affairs. Yeah.
Okay, right. So in judicial services, there are a lot of subjects which simply might not interest a person. Like, say, for example, there is CPC and I do not find interest in it. So how do I create an interest and study for it? Because the judicial services would not change its pattern because I don't like the subject.
Uh, See, what I already told you is that not to have any notion once you are into preparation. You should not
Okay.
have any notion that I do not like this subject. This subject is a burden for me, or this subject is not well enough taught in my law school. You should not be having all kind of prejudices when you start a subject or when you go for the examinations, because it will not help you. It will not help you eventually. What procedure you should adopt in studying CPC is that you should you should go in a very phased wise, in an organized way of approach. For example, if I talk about CPC, there are if people know, there are particular sections, then there are orders for the same. There are
Yeah.
there are many orders in CPC, and there are sections. So if I give you a brief or idea of CPC, the sections are the substantive part of the CPC, whereas the orders are the procedural part. In what way that substantive part are to be carried out. So if we see order 6, order 7, order 8 of the CPC, you should go for the fundamentals of any subject. For example, if you go for the CPC first, you should start from the scratch. Whenever any case is filed in a civil court, it is represented by a plaintiff. It is represented by a
Yeah.
claim that a party submits. Then you should be going to order 7 of the CPC. Then you should be going that in reply to that, the defendant files and written statement. WS is filed.
Statement.
The counter.
Yeah.
The counter that is given to the plaintiff is WS, that is filed by the defendant. Now, in between all of this suit and proceeding and the evaluation and appreciation of evidences, there are various kind of applications and various kind of stages that there are. The very famous is that interim injunctions is often asked. Interim injunction is always asked. So you should be very much clear that once a plaint has been filed, then comes the process of WS. Then there a party may ask for interim injunctions. Then there are, suppose if a party dies, then there can be a substitution application. Then if there is no, if there has been an error that a party which has to be there in the current suit is not added, then he has to be impleted. So these kind of applications are then filed into the court. The interim injunction applications, the impediment applications, the substitution applications. So you should approach in the similar way, that start with the basic proceeding, that how a case is particularly initiated in a civil court. It is initiated when you read section 26 of CPC. Then you will be read that upon presentation of a plaint, upon
Plain.
presentation of a plaint, a suit is instituted in the court of law. So the very fundamental and the very basic thing is that there should be a plaint that is filed by a party. Yes, then there comes the role of the written statement by the counterparty, or we call them defendant. Then there may be variety of the issues which may arrive between when the case goes on. The final judgment is not pronounced in CPC. We call the final judgment as a decree. The,
Yeah.
the, the judgment that is passed by the civil court finally is a decree. then so there are various proceeding that goes into between. A party may a party though which has instituted the suit may have died, so his legal heirs have to be like substituted. So there is this order 23 where the substitution part comes in. So you have to read it in the same way. Basically, you have to start with the definition part as well of the CPC. Then you should be approaching upon the kind of proceeding that goes on. You should not be starting from section 1 to end of say, CPC section 151. Thereafter, you should be going with the orders. The right way to study CPC is always to to read the section along with the corresponding orders. There are substantive section of which the procedure is explained through the orders. So once you go through the previous year question papers and the mains question paper of the particular states, you'll be getting an idea that which are the areas to be emphasized and which things should be kept into mind. So I would say that do not have any notion, do not have any prejudice like when you start with any of the subjects. You should not feel burdened whenever you are studying that अरे यार मुझे इतना पढ़ना है या I have to deal with so much of things. CPC is very much lengthy. I cannot do it. You should not have. See, there is this quote that well begun is half done. The moment you will have your fundamentals clear, the moment you will have the notions of the law clear, the idea behind the implementation of the sections, then your half work is already done. Then you have to only study with the bare act and make your notes for the same. After this, what I think is that after we have this live session being ended, by the evening or by tomorrow, I'll be sending you some of my notes that in what way I
Okay.
prepared for the same, like the major part of the CPC, because what I feel that many of the aspirants find CPC very much burdensome. So I'll be sending you some of my model notes, so you can share it in the class groups of the people or through the emails of people whoever have joined
Yeah,
this.
yeah.
This will be a very big help for them. The kind of preparation that I went through or the kind of idea that I had adopted, I'll send you the sample notes for the same for particular sections. So it would be very much convenient for the people to study from the same, I think.
Okay, right. Thank you so much for your help. And now there's this question, like a lot of people are actually asking this question, that how long did you take to prepare for a subject?
How long did I take? Yeah. Basically, I always had this notion that uh, like whenever you take TOTS or whenever you take CPC, like CPC is a big subject and that cannot be summed into the same way that you can deal with TOTS. So for TOTS, I just went into the main areas that has been asked. So for TOTS, like I decided like I'll be completing TOTS in like 15 days, 20 days. For CPC, I had like this 45 days. I had this thing that I'll complete CPC in 40 to 45 days, and whatever it may be, I will not extend it. Because if I have
Okay.
framed a deadline for me, I have to complete that subject within that deadline. Like if you see that whenever you have to achieve a big goal, like when you have to crack any of the goals in your life or whatever you think about, there have to be short goals which a person should have. And a person, what I would suggest to everyone, that they should have this short term goals which eventually